My name is Bill Brush, and I'm the president and founder of Cut Unnecessary Regulatory Burden. This video is about APCO'S dock permit, and you'll learn how it changes your property rights. We would also suggest you view the video, read your flowage easement, as that will give you a very complete understanding of these two topics. Undisputed facts. FERC regulation and authority extends only to its licensees. FERC has no authority to empower APCO to regulate state and local governments or individuals. APCO has no police powers to punish or fine. The SMP is not a law, but it is a license obligation for APCO. FERC cannot change property rights with a license or an SMP. APCO's control is limited to their property rights, which are the same as your property rights. And finally, the determination of property rights are a matter for state courts to determine, because property rights are a state matter. This is the sample drawing that's a part of the application. The purpose of this drawing is to depict the level of detail that's required in order to obtain a permit. In reality, this requires the applicant to precisely locate the dock from the opposite shore, from these imaginary property lines that extend into the water, and from the 795-foot contour. However, the sample is incomplete because Appalachian is now requiring applicants to measure water depths and to measure precisely the dimensions of the boat slips that are shown on this diagram. Many applicants have had to submit multiple surveys of this, and at the cost of $500 or $600 per survey. And God forbid, if your final dock as it's built doesn't match this drawing exactly, you'll either be modifying your dock to make it match it, or you'll be submitting a new application to Appalachian Power. APCO also requires you to submit elevation drawings. That was something that's relatively new in this version of the permit, to show what the dock will look like from both the side and the front, and detail the exact heights from the water. Well, now let's get into the occupancy and use permit that was written by AEP and that they ask you to agree to. The highlighted areas are areas of this permit that begin to take your property rights away from you. Very first off, APCO wants you to agree that it has the federal authority and the property rights to require you to submit this application and for them to approve it. At the bottom of the page, APCO's telling you here with this permit that they can limit our access and the use of project waters. That's not consistent with our flowage easement deeds. On the second page of this agreement, APCO begins to tell you there are many other conditions you're going to have to agree with in order to get this permit. You're going to agree that it's a revocable license. You're going to agree that APCO can remove non-compliant structures. You're going to agree that APCO has the federal authority and the necessary property rights to demand you submit and agree to these terms. Well, this is Exhibit B, and there are 24 conditions that you're going to have to agree with in order to be permitted to build your dock. First of all, you're going to agree in number 9 that you will not prevent the public from the full use and enjoyment of your shoreline or possibly even your dock. You're going to agree in 10 that APCO, if it determines your dock is no longer in the public interest, can order it removed. Who is APCO to determine what's in the public's interest? On the next page of these conditions, APCO tells you you will agree that if you violate any condition of the permit, they can have your dock removed at your expense. In number 13, APCO is declaring this to be a personal right. It's an agreement between you and them in order to get your dock. Well, you have guaranteed perpetual rights to the project waters through the flowage easement agreement. This nullifies that agreement. And here you must also agree to when you sell your property, that this permit needs to be reassigned to a new individual who then loses his property rights as he signs the new agreement. Well, number 15 brings in the SMP. In your flowage easement, an SMP, or a shoreline management plan, was never mentioned. But this tells you now, with this agreement, that you'll have to comply with all conditions of the shoreline management plan, or you can lose your dock. And that you also cannot modify your dock without APCO'S permission. You assume all the risk when you are granted this permit, if there should be any damages or harm that comes to you. And then in number 18, it invokes its federal license and all amendments and renewals of that license forever. This seems to be a ridiculous term because FERC can continue to change the license over the years or issue new licenses. So this agreement now is an open-ended agreement. Is it legal? It doesn't appear to me to be legal because it's an open-ended contract. Well, we're almost to the end of this multi-page agreement. This begins off telling you that if this permit expires or is terminated, that you're going to have to restore the site to its original condition. You agree in number 21 to become an APCO licensee. You agree to all terms and conditions of the shoreline management plan. And number 24, I'm not exactly certain what you're agreeing to here. This says that your flowage deed is the more important document that it controls. But I fear that if you sign this permit, that what you're stating by signing it is that the flowage right and easement deed that flows with the lands do not conflict with this permit, and consequently you give up those rights. The legacy program begins towards the bottom of the page, and this is a program specifically designed to get control over all those docks that exist in this project, some 6,500 of them, that were built without any APCO permission or permit prior to shoreline management. The selling point that APCO tries to get you to sign or agree with these legacy permit programs is that if your dock should become destroyed, this way you will be able to rebuild it. Well, there's already Virginia law in place that says that once a dock is built, it's vested. AEP is taking those vested property rights away with this on any legacy program. The idea here was if your dock was destroyed, well, you could rebuild the exact same dock in the exact same spot. But if you read these conditions, you'll find out that is not true at all. You're going to be rebuilding your dock basically to conform with whatever the shoreline management requirements at the time are. And here's 3 more conditions laid upon legacy docks. What this is really doing is trying to gain control of all those unpermitted structures in the lake under some false promise that you'll be able to replace it exactly as it was. And you can see with these conditions that is not the case at all. I would not recommend that a dock owner without any permit on the structure ever agree to one of these replacement or legacy permits. So let's go back and recall that APCO negotiated and recorded flowage right and easement deeds in the 1960s. These deeds really are a contract between the property owner and the power company. Remember that landowners granted APCO rights to flood and clear lands within the project boundary for a very limited purpose. That purpose was for construction, maintenance, and operation of the dams and power stations so they could generate and sell electricity. There is no mention in these flowage right deeds for anything like a federal license or anything like a shoreline management plan. It's an important point to remember. Meanwhile, when the landowner granted APCO the right to flood and clear, the landowner retained all rights to possess and use the easement as a fee simple owner, so long as those uses did not impair APCO's ability to flood his property. And this easement, which is very broad, runs with the title of the land forever, so that when you sell your property, the new buyer gets these rights just like you did. Well, I think we are learning that APCO'S standard permit definitely conflicts with those flowage rights you retained and those rights that you granted Appalachian, the original landowners granted Appalachian. Because in this permit, you're agreeing that APCO has the right and the authority to grant a revocable permit for your dock. You are agreeing that APCO can revoke that permit whenever it determines it is no longer in the public interest, and they are the ones that determine what the public interest is. Amazing. You're agreeing the permit is granted as a personal right. That's wrong because you have deeded rights. You're agreeing to all terms and conditions of their shoreline management plan. That's something that was never mentioned in the flowage right and easement deed. You're agreeing that the permit is subject to all the terms and conditions of APCO'S license and any changes to that in the future. Again, there's no mention of a license in the standard flowage easement. And you're agreeing that you'll assert no interest contrary to that held by APCO, and that your status shall be deemed to be that of a licensee. Well, that's the end of your property rights once you sign this document. APCO'S permit takes your property rights and they don't pay you for them. If you even want to change the permit to be consistent with your property rights, according to the APCO spokesman, you can't do that. They will consider any modified permit to be incomplete and unapproved. Meanwhile, their regulator, FERC, just idly stands by and insists it has nothing to say about this. It cannot change or adjudicate property rights. That is a matter for state court. But when this permit is recorded by Appalachian, and by the way, you're paying to record it with your $30 or $35 fee that they demand, that's proof that your property rights are being changed. Well, what can we do to save our property rights here at Smith Mountain Lake? Let me suggest a donation to C.U.R.B. C.U.R.B is a 501c4 Virginia not-for-profit corporation that is dedicated to educate and inform citizens and the community of the importance of these property rights. So please consider a good donation to C.U.R.B as we work to save your property rights and defend our property interests in court as appropriate. Thank you.